I am the one of the 8 who filed the dissent in this case, and I suppose when one dissents from as many of the court's decisions in one day as I have today, you get to discuss it. I discuss it because I think it's one of the most important opinions the court has issued in many years. To many people, it may seem that this case is of some political interest, but is not likely, now or in the future, to have any proximate effect upon their lives or the lives of their children. It does not, after all, involve freedom of speech, freedom of the press, freedom of religion, or any of the wonderful guarantees of our Bill of Rights. That is wrong. In the dictatorships of the modern world, bills of rights are a dime a dozen. What makes ours work is a governmental structure, a constitution of government, designed by 55 extraordinarily wise national leaders over the course of a 4-month convention 200 years ago last summer. That structure was designed to prevent an excess of governmental power, which is always the first threat to liberty, from coalescing. To achieve that, 2 principles were absolutely central. One was the separation of powers among 3 branches. The second was an equilibration of powers, so that none of the 3 branches could become too strong. For the latter reason, the legislative branch, naturally the most powerful because it is the closest to the people, was intentionally weakened by dividing it into 2 separate houses, differently elected, that would not always agree. And for the same reason, the executive branch was strengthened by giving it a role in the legislative process, the veto power, so that it could defend itself. And also for the same reason, the executive's power, unlike that of the Congress, was not divided, although that had been proposed at the Constitutional Convention. Article 2, Section 1 provides that the executive power shall be vested in a President of the United States. The Court's opinion today does not deny that what is at issue in this case is purely executive power, quintessentially executive power, the power to prosecute for violations of the law. Yet it holds that, despite the Constitution, a statute can enable this power to be exercised by someone who is not entirely subject to the control of the President, a mini-executive, so to speak, with jurisdiction over a very small, although in my view, a very important area. That independent counsel has authority to investigate and prosecute whether the President thinks it is justified or not, the closest advisors to the President, and indeed the President himself. We allow this mini-executive to be created because, in our view, and I quote the Court, the President's need to control the exercise of the independent counsel's discretion is not so central to the functioning of the executive branch, close quote, as to require complete presidential control. To begin with, I disagree with that judgment. I suspect that if a president were asked to list the 10 powers he thought most necessary to protect himself, practically and politically, within our governmental system, the ability to decide whether he or his closest advisors should be criminally prosecuted would surely be among them. Placing this power in someone else has, first of all, an intimidating effect upon his advisors. The present investigation, for example, arose out of a bitter dispute between the executive and Congress concerning the scope of executive privilege. Respondent Olson played a key role in that dispute, after which a committee of Congress conducted a 2.5-year investigation of his activities, including testimony before Congress, and then sent a 3,000-page report to the Attorney General, requesting the appointment of an independent counsel. For reasons I describe more fully in my opinion, the Attorney General probably had no choice but to comply with that request. I do not know, of course, whether Mr. Olson is innocent or guilty of the matters that are under investigation. But I do know that those advising the President and representing his interests in testimony before Congress in the future will, whether they are innocent or guilty, certainly act with a reduced degree of zeal. Taking away the prosecutorial discretion hurts the President, secondly, in a political manner, by eroding his support among the people. Nothing is so effective for that purpose as being able to say that X number of the President's close associates are under investigation or indictment. In the last 2 administrations, 9 highly publicized independent counsel investigations have reduced the political strength of the presidency vis-à-vis the Congress in this fashion. But more fundamentally, it does not seem relevant to me, as it does to the Court, how important the particular element of executive power taken away from the President may be. Even if we were good at assessing that, which today's opinion convinces me we are not, the Constitution did not leave the President's powers at our mercy. It says that the executive power, not some executive power, shall be vested in a President of the United States, not a President of the United States and others. How incompatible what we have done today is with what has until today been our political traditions may be made clear by thinking what the result would have been if a statute had been passed seeking to do the same thing to one of the other two branches. Would we have allowed Congress to pass a statute saying that henceforth one tiny bit of the power to enact laws relating to bubble gum, for example, would henceforth be exercised instead of by the House and the Senate by some new body established by statute? Or would we have allowed Congress to take a tiny bit of the judicial power, the power to hear bankruptcy cases, for example, and give it to tribunals other than Article III courts? The answers are obvious. A little over half a century ago, in a case called Humphrey's Executor versus United States, Justice Sutherland wrote an opinion announced the same day as the case that invalidated the National Industrial Recovery Act, which prevented President Franklin Roosevelt from removing the commissioners of the Federal Trade Commission. That was itself a reversal of our prior law regarding the President's powers. Many, including President Roosevelt, thought it an action motivated by hostility to the President's programs. But Humphrey's Executor preserved, at least in theory, the line that the Constitution established. It allowed the restriction upon the President's power because it found that the Federal Trade Commission did not exercise purely executive power. Today, however, the Court concedes that what we have before us is precisely that. It effectively overrules Humphrey's Executor and says that in the future, how much power can be taken from the President will depend upon, quite literally, our case-by-case evaluation of whether what has been taken from the President is too much. I do not think we are qualified to decide that. More importantly, I do not think we are authorized to decide that. All of us are familiar with and proud of the phrase that we think epitomizes our political system, a government of laws, not of men. Not many know where that came from, which is the first Article 30 of the Massachusetts Constitution of 1780, which reads in full as follows: "In the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them. To the end, it may be a government of laws and not of men." That is how central the founders of our republic thought the separation of powers was to our system. That is what achieves the end, that it is a government of laws, not of men. And as the founders knew, separation cannot be preserved without equilibration. Today's decision, which departs from the text of the Constitution and gives no reason for the departure, except that a majority of this Court does not think that the power taken away from the President was too much, is not, in my view, the operation of the government of laws that the Constitution intended. Indeed, it does not seem to me to be the operation of a government of laws at all.
Justice Kennedy took no part in the consideration or decision of that case.